Jacinda Ardern.
Thank you, Mr Speaker. Mr Speaker, I think the Minister is absolutely fair to reflect the amount of work that has clearly gone into this bill, and the Select Committee process was a place for robust debate and discussion. And after that robust debate and discussion and our attempts at committee stages to make a number of amendments, we have unfortunately had to make the decision that on balance there are elements of this bill that we simply could not support. But Mr Speaker, there were elements, and I would include in that the purpose of the bill generally, that we did support. If we come back at the point that it was first introduced, it set out as the commentary of the Select Committee states that the primary aim of the bill was to seek to improve the timeliness and efficiency of the coronial system by amending the Coroners Act 2006. And I think that's a point which we could all agree on. At the moment, there are significant delays in our coronial system. The Minister spoke today in Select Committee estimates of the fact that there has been a 20% reduction in the time that these cases are taking, but even then, there is a significant backlog. And during the course of this debate, I had a family member of someone who is the subject of a coroner's case who had waited more than 1,000 days, and that is not unusual. And that length of time is absolutely devastating if you're a family member waiting for closure in a case. So, look, when it comes to the substance of the purpose of this bill, we certainly supported it. We'd also use this opportunity to just state a few concerns that whilst we want the backlog of coroners' cases to be dealt with, we do have concerns that there has been talk of contracting out, bringing in external legal services in order to facilitate the processing of coroners' reports. Our worry with that is that this is a legislated function that a coroner holds, and it does muddy the waters somewhat to be having external legal services processing those inquiries and inquests. Mr Chair, if I could come to the areas where we still have concerns we considered significant enough to, on balance, not support this bill. The first, which we didn't submit an SOP on, but which did stand out for us, sits under 57A of the bill, and that sets out what a coroner is able to make recommendations around. This bill used the opportunity to narrow that function. The point that I would make, that if this bill was really about just trying to make the system more efficient, it's not at the point that a coroner is writing recommendations that really we're seeing a lag in processing. The point at which the coroner is sitting down at a desk, as it were, with an administrator perhaps to say, look, well, these are the things that I finally deciphered from this report, that's not the thing that's leading to 1,000 days before a report is issued. So to argue that to narrow the ability of a coroner to write a recommendation is going to save time or efficiency necessarily, I think is a stretch. I think instead it impedes on a coroner's ability to speak to the points that they considered valuable. And the specific recommendation that the Chief Coroner spoke to that they were concerned was a narrowing of their ability is under this 57A 3A, which states that a recommendation must be clearly linked to the factors that contributed to the death to which the injury relates. We've used it in a few examples previously, but just reading one of many forestry deaths that tragically have occurred in recent years, one determined cause of one of those deaths was that there were high winds in the area when a tree came down on a forestry worker. Now, in that circumstance, a coroner may only feel able to make recommendations that relate to the fact that this was an accident obviously caused by high winds that caused that tree to come down. But to what extent are they able to speak to the wider context of fatigue, long hours, the effects of the way that contracting works within the industry, other factors that may have led to the potential distraction for that worker, the pressure they may have felt to continue to working in those environments. This recommendation, this clause potentially limits a coroner's ability to make those wider recommendations. So we thought that was problematic. The second area we had concerns with, and I'd have to say this is a real sticking point for us, and that is not what was included but what wasn't included in the bill, the lost opportunity as it were. And we've spoken about this at great length. And that is that most people might be surprised in New Zealand to learn that when a coroner makes a recommendation, there is no obligation on anyone who might be the subject of that recommendation to reply, to respond, to give a written view on that recommendation. And that view may be that it's a ridiculous recommendation and should not be implemented. But actually there's nothing to say that they need to say anything at all. Now that seems to be a crazy situation when we are funding at great expense to the taxpayer a coronial system that can write a recommendation and a report that can go absolutely nowhere except perhaps to the family. Now that seems ridiculous. And I'm not the only one who have made that declaration. There is the Law Foundation recently funded a student of Victoria University to conduct a piece of work, as you can see here, a sizable piece of work on the very question of whether or not coroner's recommendations should be responded to on a mandatory basis. What they found was that there were, and this is of interest, that there were 607 coronial inquiries over a 5-year period. That resulted in 1,644 recommendations. There were 309 recipients of those recommendations over 5 years, 309 recipients. Government organisations received the highest proportion of recommendations. That's interesting. The people that we protected in this House by refusing to accept an SOP that made responding, not implementing, responding to recommendations mandatory were government departments. Surely, given that this legislature are the ones that are requesting and guiding coroners in the work they do, we're telling them how we want them to operate, how we want them to be more efficient, how we want their recommendations to be more punchy, but on the flip side, we're saying, but if you issue them, we're not going to make our government departments do anything with them, which seems nonsensical. It then goes on to describe that of the most frequent set of recommendations, they included transport accidents, drowning, intentional self-harm, and complications of medical surgical care. Transport accidents, this House has an interest in. Government departments have a direct role in the way that we regulate in the prevention of transport accidents. So it is relevant to us and we should want to know. Drowning, if it's a regulation that relates to the fencing of swimming pool acts, we should want to know. Intentional self-harm, of course, when it comes to mental health provision, we should want to know. And I note that the Auditor General today has issued a report on the reporting and gathering of information around self-harm. Surely amongst that we should be saying what is happening to our reporting of recommendations. And complications of medical surgical care, again, very relevant. The report rightly summarises that the government review, that's this Act, presents an opportunity to initiate much needed reforms. A review that includes few proposals to enhance preventative functions may mean that coroners' recommendations are a lost opportunity to save New Zealanders' lives. And that's exactly how we see it. To briefly summarise our remaining concerns, Mr. Speaker, what's been well traversed by my colleague Phil Goff does include the Defence Force provisions that they requested in this bill, the reversing of onus so that deaths in hostile action will no longer be the subject of a coroner's inquest. They will only incur if the Attorney General orders that it occur. Our view is that that should be flipped. It should default to the coroner to add transparency for those families. Those in and of themselves were enough for us to say that although we support absolutely narrowing the number of cases that coroners are having to deal with to make it more efficient, to get more timely responses, the mechanisms that have been used in this bill went too far. They went too far in our view, and there was a lost opportunity as well. So, Mr. Speaker, on that basis, reluctantly, Labor has decided that we cannot support this bill. We will be keeping a close eye on the changes, though. We do support the general intent, but we must be the ones that try and preserve transparency in our system and the ability for coroners to make the recommendations that they feel are necessary for our safety.